Madam Speaker and Mr. Speaker Pro Tem, please go ahead and make your opening comments.
Thank you, Mr. Chair and committee members. Today we bring before you Senate Bill 157, which clarifies and updates Colorado's open meetings law. I want to start first by thanking our co-prime in the Senate, President Fenberg, and also the Colorado Press Association, the Colorado Broadcasters Association, and our own Office of Legislative Legal Services for their help and contributions as we have worked on this bill over the past few months. I want to emphasize that as this bill has been moving forward, we remain open to hearing from groups and constituents on how they would like to ensure that we have transparency in the work we do here. You know, I believe that we as legislators share a common value, and that is the belief that the democratic process thrives when communication, deliberation, and decision-making are open and available to our public. Colorado voters sent their elected representatives to the Capitol to work on their behalf, and it is important that we govern the state responsibly and transparently. The Colorado Open Meetings Law was written in 1972 and then updated in the 90s and is now out of date with our modern legislative workplace. There's been significant ambiguity on how to apply OML, given that cell phones, emails, and text messages have become mainstream communication tools in this digital age. Additionally, the phrase public business was never clearly defined and has been open to interpretation and even confusion. Senate Bill 157 updates and clarifies the open meetings law as it applies to the General Assembly. I also want to emphasize that Senate Bill 157 maintains the spirit of open meetings law in requiring that public notice be provided and minutes taken for any meeting at which a quorum of a state public body is present and public business is being discussed and or voted on, but provides clarification and better definition on several key provisions in the law. So, Colorado Open Meetings Law passed as a citizens initiative in '72. Since then, the legislative proceedings of the General Assembly have become far more accessible, an advancement made by digital technology. At a minimum of 6 different points throughout the legislative process of a bill becoming law, at least 2 committee hearings, if not more, and 4 floor debates, proceedings are now broadcast or streamed live on the General Assembly website for the public to observe. Email, digital communications have now become the norm and most efficient form of communication in any modern business, modern workplace. Open meetings law has not kept pace with our changing world and simply cannot be applied as written to electronic forms of communication. As written, our open meetings law is vague, confusing, and in many instances impossible to comply with. In the most recent guidance from the Office of Legislative Legal Services, there remains significant ambiguity around what constitutes public business and is therefore subject to the provisions of OML. Not only is there a need to modernize this outdated law because of digital communications, now more than ever, there is a need to ensure that the democratic process in Colorado continues to thrive. We must create space to share policy proposals with one another, build understanding with stakeholders and colleagues on the contents of complicated statute, and have the chance to persuade members to support our legislation. For many years, and especially following litigation this past summer, lawmakers have navigated this building and this legislative process now in uncertainty. And this uncertainty has caused members to stop talking to one another. That is a detriment to our democratic process. It has also led members to rely more heavily on our lobbyists instead of working directly with each other. The result has been a notable shift in the power dynamics between legislators elected by their constituents to represent their interests here at the Capitol to unelected lobbyists who are paid for, frankly, by clients and also special interests. I am not being critical of the lobby, please hear me. They are partners in this work, but it is an acknowledgement that when we can't speak to each other, we end up using lobby as our partners to help us accomplish that communication. This means that for most bills brought by constituents or community members, There isn't a lobbyist on hand to work with other members, and clearly another disadvantage to our process. Failing to engage with one another on such critical policy-making matters has shifted the tone and tenor of how we do our work here in the General Assembly. And as many have observed, including myself, the culture of the legislature has begun to deteriorate over these past few years, starting to feel less like Colorado under this gold dome and more like Washington, D.C. Relationships matter in this building. Understanding different perspectives requires a commitment to spending time with constituents, stakeholders, and each other, and then opening our minds and hearing and listening to the other side. That time isn't available in one conversation, in one committee room, on one bill. There isn't enough time for us to engage and deliberate in a way that is productive unless we can find that availability outside of this particular process that we're in today. We need to find that understanding, that time, so we can build a ground for compromise, improve policy by avoiding unintended consequences, communicating both sides of an issue to our constituents, and ultimately reaching a level of understanding around policy to move it forward. The democratic process thrives with civility and respect. Civility and respect grow when we understand each other, build relationships, and commit to learning. This is why updating and clarifying the Colorado Open Meetings Law is so important. Thank you, Mr. Chair and members. I turn it over to my co-chair.
Thank you, Mr. Speaker Pro Tem.
Thank you, Mr. Chair and members of the committee. I want to start by just reminding us what the two main types of provisions of the open meetings law are. First, there's just the requirement that any meeting between two legislators, two or more, must be public. And this typically means if you are having a conversation in the hall and someone happens upon the meeting, or if they have advance notice, you must allow members of the public into those meetings. The second is the requirement that if you have a quorum of a state public body meeting, you must provide advance notice of the meeting in a public way and keep minutes of those meetings. So establishing that baseline, I'm going to talk about what's in the bill and what we're trying to do here. First of all, this bill only applies to the General Assembly. While it's true that local governments have also expressed that they feel many provisions of the open meetings law are difficult to understand and comply with, it does make sense that there would be a different standard for the General Assembly because we operate very differently. Whereas local governments are often governed by between 3 and 13 elected officials, we're a body of 100. In a smaller body, you can see how a member could work through individual conversations as kind of a workaround to the public quorum requirement. But that's a lot harder to do when you're talking about 99 other legislators you have to talk to. In addition, local governments typically have, 1 or 2 votes on a policy, a first and second reading of sorts that they do, but they don't have a bicameral system where you have the multiple committee hearings and multiple floor debates. And so, something I think a lot of us have experienced is maybe the first time a bill goes to committee in the first chamber, there may not be a lot of people that show up. But then by the time it gets to the second chamber, if it's a controversial bill, an awful lot of people are going to show up to testify on that bill. So we have many opportunities for public access to this process. This bill is largely a clarification of provisions of the existing law that have been difficult to interpret. The bill does preserve numerous provisions of the existing law, and in many cases makes those requirements more explicit. And this bill does not exempt the General Assembly from the Open Meetings Law or the Colorado Open Records Act, and it does not make our processes less transparent. Rather, it sets a clearer standard that we can all look to in the years ahead. And by we all, I mean you all, because I'm not going to be back next year. So now let's get into the specifics of what this bill is really trying to do. First, it clarifies that written communications, electronic or otherwise, are subject to CORA, not the Open Meetings Law. This means that a member of the public can request written records, but the legislators don't need to provide notice of an email blast to their caucus or to keep minutes of a text exchange. Second, and I mean, it seems kind of silly to say that, but this is kind of an actual interpretation of the language that was added to the OML in the 90s that has led to this idea that an exchange of emails is a meeting, which I think it's fairly obvious how difficult that is to try to interpret as a meeting as opposed to a record. Secondly, the bill defines public business to include introduced legislation, an official bill draft, or other matters before a committee. This means that public notice must be provided and minutes must be kept for any meeting of a quorum of the state public body discussing this kind of public business. For the most part, this simply affirms what has been a common understanding of what the open meetings law has always said. But what it also makes more clear is that when you're having a more informal brainstorm, that you don't necessarily need to invite the public into a brainstorm session where you're all floating your ideas that have not been thoroughly thought through. And this most commonly takes place in the interim. We all get to the end of the legislative session, have a little bit of a breather before we start getting back into preparing for the next session. But a lot of us start having these conversations in the summer, and sometimes they're caucus meetings, sometimes they're gatherings of groups of people that have an interest in a similar topic, where you don't have a bill draft, you haven't even requested a bill title, but you want to talk about an idea and say, is anyone working on this topic? There's this really big problem. Sometimes those brainstorming meetings do need to be able to happen in a safe space where you don't necessarily have the lobbyists who are going to oppose your effort looking over your shoulder. We need to be able to have those safe spaces for those conversations to happen, especially when it's so far out from when a bill gets introduced and so far out from when a vote is actually cast on that procedure, where there will be ample access to the public when that time comes. The third thing the bill does is it defines a quorum to be contemporaneous. This has come up because of the suggestion that a de facto quorum could be achieved through a series of one-on-one conversations in a bad faith workaround of the law. We recognize that concern and we agree there should not be bad faith workarounds of the quorum requirement. But I think all of us know how important those one-on-one conversations are. And I don't want this to come across as a straw man, because this is actually the tension that we've been grappling with on this bill. Anyone who's successfully passed a bill through both chambers knows that a big part of the process is going to the committee members that are going to be hearing your bill and saying, are you comfortable with what I'm trying to do on this bill? If not, okay, what kinds of amendments might address this concern? Now, when those amendments ultimately come to be, those are introduced and discussed in a public meeting where everyone's vote on the amendment is taken. But if we take away the ability for a member to actually go work their bill and work through that process, it really would cripple our ability to do this work. And it's just, these one-on-one conversations are vitally important to us successfully doing our jobs. Just think about what it would look like if we didn't get to have any conversations. You show up to a committee with your bill, having talked to no one, and you find out everyone hates your bill, but you could have fixed it had you known in advance, had you known what those amendments are. This is something that we need to take into account. That's a real concern. And I really, like I said, I don't want to oversimplify this, but trying to figure out where to draw the line between these things has been a real challenge that we've been wrestling with for several months. How do you make sure that you're not opening the door to these bad faith workarounds of the process while continuing to preserve the ability to have the one-on-one conversations? It's incredibly tricky, and if anyone on this committee or anyone in the body or the room has other ideas about how to more clearly define this, I think we are very open to it, because this is our best attempt at figuring out how to define it, but we're not here to pretend it's perfect either. And let's also remember that there's no requirement in the current law that meetings between a legislator and a lobbyist be open to the public. And this is something that I actually think would be of interest to a lot of members of the public, but I think we all know that we're taking these meetings all day, every day, and this is not a practical thing. And so if we cut off our ability to talk with one another, it is true that the lobbyists are going to be the ones counting votes. The lobbyists are going to be the ones working amendments and trying to work on these arrangements. I would argue that makes this system less transparent, in addition to breaking down the relationships we try to develop with each other over the time that we're here. I want to be clear that nothing in this bill changes the requirement in current law that a meeting of 2 or more legislators be public. We are not touching that section. It is what it has always been. The bottom line is that this bill affirms and clarifies what has already been a common understanding of the law and will provide greater clarity for future General Assemblies. Because of the robust process it takes for a bill to become a law, we've all seen Schoolhouse Rock, there will be numerous opportunities for engagement between legislators and the public will know how every legislator votes on every bill and every amendment. I want to end with just a big picture reflection on the choices before us. I think we all agree that public transparency is incredibly important. And so are our relationships with one another. This country is as polarized as it has ever been, And the only way through this is for all of us to dedicate ourselves to more communication and building better understandings of one another's values and priorities. Thank you again, committee, for hearing this bill today. We look forward to your questions.
Okay, thank you, Mr. Speaker Pro Tem and Madam Speaker. Members, questions of the sponsors? All right,
I'm sorry, are we in the Judiciary Committee?
the last one was a tough one, Mr. Speaker Pro Tem. We might still be in the Judiciary Committee. All right, if there are no questions, we'll go to witnesses. We have 5 signed up. I'll just make one hybrid panel. Mr. Umbala, if we could please look on the Zoom for Corey Gaines and Linda Hutchinson. And then in the room we have Mr. Roberts, we have Kathleen Gegner, Gegner, and Natalie Menn. Now, was there anyone else who wanted to speak to 157 who didn't sign up? Okay, please come up. All right, we'll start in the room, then we'll go online. Why don't we start with you, sir?
Thank you, Mr.
And sorry, standard instruction, when you're speaking, please make sure the mic's on. There's a little tiny gray button set into the table by the black plug. When the light is green, you're good to go. There we go.
Am I on? Yes. Thank you, Mr. Chair and members of the committee. My name is Jeff Roberts. I'm Executive Director of the Colorado Freedom of Information Coalition, a nonpartisan group that promotes government transparency and helps journalists and the public understand and use Colorado's open government laws. The views of our executive committee may not necessarily represent the views of all of our member organizations. CFOIC urges a vote against Senate Bill 157. While we understand that the open meetings law as it pertains to the legislature may need some modernization, CFOIC believes the bill strays too far from the intent of the law as passed by the voters of Colorado in 1972. The Sunshine Law said then, and it still says, that it's the policy of this state that the formation of public policy is public business and may not be conducted in secret. Senate Bill 157 undermines that principle by allowing and encouraging members of the General Assembly to discuss public business in an unlimited way by electronic written communications, email, text message, disappearing messaging apps like Signal, all outside public view without being a meeting subject to the law. Under this bill, not only would the exchange of electronic communications be exempt from the open meetings law, the electronic communications themselves, if they continue to exist, would likely not be available under CORA because they would be defined as work product, excluded from the law's definition of public records. The people of this state will likely know nothing about these discussions either at the time they occur or any time afterward. If unlimited email and text message conversations are to be allowed, the legislature should consider finding a way to make more of these communications available so that journalists and the public can see them. Lastly, CFOIC would have been happy to discuss open meetings law modifications with the bill sponsors. There are 3 expert attorneys on our board, one of whom actually drafted the 1991 amendments to the law. But unfortunately, we were not included in the stakeholding process. Thank you for your time.
Okay, thank you. Whoever would like to go next, or we can just go down the line. Okay.
Thank you. My name is Kathleen Gegner. I am testifying on behalf of myself in opposition to Senate Bill 24-157. This bill is an integrity bill for me. It is interesting that Senate Bill 157 is being brought forward by the leadership of the General Assembly that has repeatedly violated Colorado's open meeting law. It is interesting that a bill sponsored by the President of the Senate and Speaker of the House has moved through the Senate and is now appearing in a House committee before a similar, though more constructive bill has even been scheduled for a committee hearing. It is interesting that Senate Bill 157 insinuates a desire for transparency when the very nature of the bill contradicts transparency by limiting what can be considered public business or a public meeting and restricts electronic communications. It is interesting that I'm testifying on this bill before a committee where 2 members who sued the House and Speaker over open meeting law violations were removed. So, it is very hard for me to believe this bill has been brought forward in good faith to ensure transparency and to affix issues in the open meetings law. To name a few specific issues, The definition of public business shouldn't be narrowed as proposed by the bill sponsors. Further, it certainly shouldn't exclude meetings where policy development occurs prior to becoming proposed legislation. Before a bill becomes proposed legislation is the best time to carefully evaluate, brainstorm, and explore policy ideas, and the public should be able to see this. Blanket exclusion of electronic communication is too limiting. Third, logistical matters should not be excluded from public business. If legislators are determining when bills get scheduled and what theatrics should ensue in committee and floor work, the public should be allowed to know about those logistics. Matters that address training should also be public business, so the public knows what kind of training you all are getting. Lastly, letters C, L, and N should be stricken from the legislative declaration, as they are misleading and do not align with what's proposed in the bill and do not align with actions of the General Assembly, which would make these statements false. Please vote no on Senate Bill 157.
Thank you, Mr. Redenford.
Chair and members of the committee, thank you again for the opportunity to speak today. In addition to the Colorado Press Association, I'm also testifying on behalf of the Colorado Broadcast Association, as my counterpart, Justin Sasso, is not there. I'm here testifying in an amend position on Senate Bill 157. First and foremost, CPA and CBA appreciate the open dialogue that President Finberg and Speaker McCluskie have provided to our associations to assist in reforming Colorado's open meetings law. We remain committed to maximizing transparency and preserving the intent of the open meetings law. We also understand that the Colorado General Assembly creates better public policy when legislators have the ability to speak to each other as professional colleagues. We appreciate the requested changes already made to SB 157, which I won't enumerate here, but I will highlight a couple of recent ones. And adding to the definition of public business any quorum discussions of proposed and drafted legislation is a meaningful improvement. Requiring review of the law and its impact is also valuable. While I understand that the intent of the bill is not to harm transparency, rather make the important process of making laws workable, and that can be very difficult to craft language to cover all scenarios, it's also important to recognize that norms do change, and we do not want this bill to open loopholes and allow for legislation to be hammered out behind closed doors. We're concerned about two things in those regards. One, we're concerned that serial or daisy chain meetings could be used as a way to potentially subvert doing public business in public. We understand that the ability to have one-on-one conversations is a key goal, and there's an inherent tension here. While we've had numerous positive conversations with the sponsors, we have yet to find a way to thread that needle, but are committed to continuing the effort. Two, we are concerned that completely omitting electronic communications from OML and solely relying on quora could introduce delays in transparency. We understand the logistical implications involved in making an email an open meeting and the fact that this bill codifies current practice. However, the current definition of work product, along with the lack of consistent records retention policies of the legislature, do create some transparency concerns. And I think it's important to acknowledge that. I hope you all agree that this is the open meetings law is vital to preserve the ability of the public to understand and interface with what's going on, and we hope we continue to work to avoid any potential loopholes that this bill opens up.
Okay, thank you, Ms. Ridden.
Natalie Menton, representing myself. I see this measure as a response to a lawsuit that was basically addressing sidestepping public meeting laws. And it really comes down to where's the conversation that occurs, because when I heard the sponsors talk, they were talking about the relationship between themselves and other members of a committee or the body of the other 99 members. But where is the public affected in this change? And I say that as a citizen journalist, somebody who is taking time out of my day, not paid to do this, to try to keep up with what government is doing. But I've been an elected official also for 8 years, so I understand the struggle between being able to discuss policy before it's formally published. During my term as an elected, I was happy to share those things. And if there was controversy, if there was dispute, if there were arguments, I was very willing to have that discussion in a public forum. It was asked about some of the solutions that potentially could exist. It's interesting, in this day and age, we have public forums that offer the option of public discussion and being able to comment and perhaps ask those silly questions, or does anybody know what this may be or the impact, because I'm having problems envisioning all of it. Why are we shying away from those public discussions? There was statement that there is always abundant discussion. That is not the case at all. I can think vividly back to last year with Senate Bill 303, introduced on a late Monday afternoon and heard in committee less than 24 hours, roughly 24 hours later. How was there to be public and abundant discussion when that occurred? I can think then to the following Saturday when I was sitting, listening to testimony in the hearing, and out of the blue comes a bill introduced, House Bill 1311, addressing TABOR refunds, which was heard in committee without even paperwork present when the committee meeting started. How is that abundant discussion? It isn't. The special session, the posting of the bills at the last moment, some of them not even in advance of when the session opened. The special session opening by waiving rules about transparency. I have to mention a couple things. When I went to dig into the discussion that occurred about Senate Bill 303 and 1311, in retrospect, I was quoted a figure of over $1,200 to get those public records. So even later, those records were not available. Where did the discussion come from? Shouldn't the public know? I'll just close with the Democratic platform, which will be decided in your caucuses here shortly, states, and open government, accountable government depends on being informed in issues and the workings of government. And then with government ethics, close here. Number one platform plank for the Democratic Party: require the executive and legislative branches to maintain publicly available logs of government officials' interactions with lobbyists and constituents. This bill does not help that platform plank. Thank you.
Thank you. If you all please hold, we'll go to our witness online and we'll open up for questions. Ms. Hutchinson, please go ahead.
Mr. Chair and members of the committee, thank you for the opportunity to testify. My name is Linda Hutchinson and I represent the League of Women Voters of Colorado. The League is a nonpartisan organization that encourages informed and active participation in government. The League of Women Voters of Colorado opposes Senate Bill 157, Colorado Open Meetings Law, for the General Assembly. The League does acknowledge the efforts of the sponsors in working to clarify Colorado's open meetings law. The League of Women Voters believes that government has a responsibility to be open so that all voters have access to information about government decisions and play their designated role in the democratic process. Some of the comments that have been made about the daisy chain meetings, that's a repetition of what I wanted to say. So I'll move on to, this bill states that written communication exchanged between members of the General Assembly is not subject to open meetings law, but records of the communications are subject to KORA. That statement shifts the responsibility for open government and an informed electorate from the government to the voter, and it places an undue burden on the voter because filing a KORA request takes time and costs money. An open government is particularly important today when newsrooms are stretched very thin and disinformation continues to spread. Studies show that disinformation thrives in information voids. This bill keeps too much information in the shadows and runs the risk of only adding to the problem of disinformation. The League encourages you to vote no on this bill. Thank you for the opportunity to testify.
Okay, thank you. Now we'll open to questions. Rep. Amabile.
So I have a question about this one-on-one, us meeting and talking about what we're working on and how that connects to this hub and spoke and daisy chain. And I have the impression that we are no longer allowed to basically go to each of our colleagues and say, do you have any questions about my bill? And we could maybe go to one of our colleagues, but we couldn't go to all of them. And we also can't have them ask for us. So this session, I've seen us come to committee without knowing, we have no idea what's gonna happen with our bill. We are running amendments in the middle of the committee. We are still, it seems like we're not doing as good a job for the people of Colorado because we aren't able to have those conversations. And so I just wonder what you all think about this limitation on this daisy chain and hub and spoke communication. And I don't view that as being some nefarious backroom dealing. I hear maybe you all do, but it's actually doesn't feel that way in real life. It feels like I'm trying to do the best job I can do in terms of running legislation that people are comfortable with and that I've heard their concerns and maybe responded to their concerns. So I don't know who wants to answer that.
So Reprimand kind of for anyone in particular.
Well, no, I mean, I see somebody with a hand up, so.
Yeah, if you'll just note your name again for the record and feel free to respond.
Natalie Menton. So in my view, Representative Luck has a bill which would optionally allow sponsors to post their bill when it is in a preliminary stage, be able to get that feedback almost along the lines of a message board. It is just really concerning when it's been narrowed to that somebody is choosing who wants to be the stakeholders. And there's a lot of times where the public is not invited to that table and not considered a stakeholder. So I've avoided using the word a lot in my political life, but that kind of a message board where the committee can see these things. I mean, it'd be lovely if we were, as a public or the committee, being able to see the amendments before, 40 seconds before testimony begins on something. That's my vision.
Well, I would.
Reprimand, go ahead.
Yeah, thank you. So I would just say, but that's not, as a result of this lawsuit and this session, we are, being responsive to that. And so the opposite of what you're asking for is really what's happening. Amendments are literally being drafted while we're in here. And so I'm not sure that limiting our ability to have conversations with each other is resulting in the thing that you want.
A couple of things, and I'm sorry I'm gonna phrase this maybe as a question, but one of the things you asked Amabile was how to notify or ask your colleagues. My understanding is that you can email your colleagues, and if that's not okay by the open meetings law because of the notice required, a fix would be to that portion of it that doesn't require notice of email being sent as a way to understand where your colleagues are. Second thing, the background I come from is the Public Utilities Commission, where the commissioners cannot speak to one another because of the open meetings law. And so they're developing very technical policy around gas and electric utilities and so on. And they have to have a public meeting to do that debate. And so something like an office hours where the bill sponsor could post and say, I'm talking about this, anyone who is interested in asking questions, developing amendments, it'll be at this time, bring your ideas. To me, that feels like a better form of governance.
Sure.
Yes, Jeff Roberts. The legislature passed an amendment to the open meetings law, I want to say something like 3 years ago, regarding electronic communications, and we did not oppose that. It basically says that elected officials can exchange written electronic communications without violating the law that pertain to scheduling, sharing information, things like that. But when they get to the point of actually, can't remember what the wording is, but the merits and substance, I think it says, of public business, then it crosses the line. And so to me, that's a good guideline that allows you to use email and all that to do those types of things. I think the bill as it's drafted now would allow quite a bit of discussion even amongst a lot of members of a single committee by electronic communications, and no one would ever know about it. And perhaps even coming late in the session when things are moving very quickly and bills, like Natalie said, get introduced and decided very quickly, that these could be decided by email or signal or something like that. That's a worry, I believe.
And then I'll be done. So, I mean, that's interesting. So you're suggesting that we would do this by email, and then those email records would be Quora-able, so that would be preferable to us just having a conversation?
What I'm saying is that I think, no, I'm not suggesting that. I'm saying that in our mind, the bill encourages those discussions by email, and someone could Quora for them, but I think a lot of them, especially if they involve amendments, would be claimed as work product.
Sorry, but I'm just trying to get at this, us having a conversation. Like you and I are kind of having a conversation with Rep. Weissman helping us, and it's very different than you and I sending each other email. And so I'm asking about our ability to have these conversations with each other, and wondering, what are you all suggesting about that?
So I think that that's always been the way the legislature has worked, and there's always been accommodations for that. I was a State House reporter for the Denver Post in the 1980s, and I knew that, the open meetings law was pretty new at the time, but I knew that what it did, and in most cases, as a reporter, I was not going to insert myself into those conversations. But when Speaker Bledsoe back then was meeting with a bunch of people in his office on a matter that I knew was important and newsworthy, I might insert myself into that conversation, knowing I had the open meetings law on my side. So there's always been accommodations for the strict interpretation of the open meetings law, the two or more, and until recently, no one has challenged that. So I think that would continue.
Let's go to Rep. Garcia now.
Thank you, Mr. Chair. I just a question as I'm looking at this and looking at the way that if this passes, how things would be practiced compared to even just last year. And when I'm seeing this, I'm thinking, wow, this is even just demonstrably more transparent. So the fact that we even have in here the clarification that proposed legislation is not simply an introduced piece of legislation, but it is in fact, once it hits bill paper, meaning that OLLS works on it, then it's a matter of public business. Last year that wasn't the case, right? Last year, I can think of a member who sued us, yet flipped out when her bill was released pre-introduction. So I'm just thinking that this, to me, feels like this is actually something better. It promotes greater transparency. Am I missing something?
Rep. Garcia, for anyone in particular? Or okay, whoever would like to, as before, there's no unit, please go ahead.
For me, I see it's the lack of transparency because the work product is being used whenever it's wanted, but then there's a claim that discussion and stakeholdering was done, but it was only done with selected members. The work product, if I would have spent the $1,200 on a Quora for the 3 members, so the sponsors, I wasn't going to get anything. All I would have gotten in the Quora was press releases, basically junk mail. It wasn't the discussions. So our problem is really going beyond this. This doesn't solve anything. The work product exclusion is there, and the public's left out of it. We're not part of the workings of government, which are embedded in that democratic platform that I spoke to.
Just one last question, comment. I also wonder the role of, for example, interim town halls. I know a lot of our policies are discussed and ideated through these public town halls we hold. I don't know if my bills are just not interested. I've never seen media at my town hall. And so I just question, like, there's these opportunities that already exist to be able to participate, you know, whether it's a virtual town hall or an in-person town hall, or say, hey, I can't go to your town hall, but this is what I think. And so I think that there are mechanisms in place where we can have these discussions with the public, and not even selected few who we personally invite, because I don't know any, I hope none of my colleagues are selective in who they open their town halls to. And so I'm curious if the idea of participating in public policies from some of you is limited to what happens just in this building.
Anyone who'd like to?
Let's try this reaction. So I have a little bit of experience with how some energy policy has been created. And I think one of the keys is the community engagement, as folks I know who have worked on drafts and what that could look like. Because it's not legislators, that's out of public view. But if there are legislators doing that sort of conversation to come up with that policy, maybe it is a joint town hall where folks who are interested in that topic could come together and hear about what they're thinking and work towards a constructive policy. And so I think that's where I'm coming from, is that we don't want to limit that brainstorming that Speaker Pro Tem spoke about from folks who may have good ideas to offer but can't do it in a 2-minute forum once the bill has been introduced, or even once it's hit draft paper. So that's really where I'm coming from.
Repair.
Thank you, Mr. Chair, and my questions are very similar to my colleague, Representative Garcia. And so my question is, I'm sorry, I didn't get your name.
Jeff Roberts.
That's right, Jeff Roberts. Thank you, Mr. Roberts. When you mentioned the example of Speaker Bledsoe, did you use that opportunity to go into a meeting that he was having on a bill that you were interested in?
Yes, it's a long time ago, but I don't remember the bill, I don't remember the subject matter, but what it would, it would be, hey, I hear there are several representatives in the speaker's office, it's about this, and it's about something that is of a story we were covering. So as a journalist, and I haven't been in that role for a long time, covering the State House, but you pick your battles. And I believe the State House reporters today sort of pick their battles in that sense. I've had some conversations with them where they're not going to insert themselves into every single conversation they see, but they might on a few that they think are really important.
Thank you, Mr. Chair. And so when you did insert yourself though, and I'm not sure if you said you were there before open records or not, but were you denied entrance, or did you have to say open meeting, I'm allowed to be here? Was there any issue afterwards with the speaker because you did that?
I don't remember there being an issue with that.
Thank you, Mr. Chair. And I think what I'm trying to get at is like, what, for someone who's been working in the Capitol, what is the difference between practice and policy? We know that we've had the open meetings request, but we've had meetings, and they have been known about, we'll say, with the press corps and with folks outside of the press corps. But the practice is not to be there unless it's very rare. And then there tends to not be an objection from the member, because of course you don't want the article saying that you were having some closed door meeting and no one was invited, right? And so I'm trying to find that nuance about where we find this is different between practice and policy. If you have any other things to say to add to what Representative Garcia mentioned.
Well, one of the things in one of the lawsuits last year, as I recall, was an allegation that some of the caucus meetings were not known about, that they were purposely left off calendars. I don't remember what the judge the judge didn't conclude anything in that case because there was a settlement. But that was one of the allegations in there that some people didn't know about these caucus meetings, and caucus meetings are de facto public body meetings under Cole versus State in 1983. So that could be an example if that allegation was true.
Thank you, and I'll end there, that's very helpful. I mean, those meetings though, the press corps were very well aware of that, before, and I think that's why we see the lawsuit now, right? So they were very well known, but that's really helpful, and as we, I think, get through this, if you have any other ideas that come to mind, feel free to grab me, I'd love to talk to you more about it, and thank you guys so much for your time.
All right. Members, we have run actually past time on this panel. Thank you all for testifying with us. All right, Mr. Mbala, confirming no one else online for this bill. Final call for anyone in the room.
Thank you, Mr. Chair. And committee, I did not think that the timing would line up for me to be able to hop in as I was listening to part of it in the air. I don't rise, I should say I rise in. I oppose this bill because I support transparency. I am a former public defender, which makes me a perpetual optimist and believer in the opportunity for folks to get things right and do better. The process of seeing what has happened both with this bill and our work around transparency has not dimmed that optimism, but definitely is close to chipping away at it. The two main things that are, at least as I saw it amended from the Senate floor, the two main things that are wrong, if I were just going to narrow it, one is that the work around walking quorum or versions of hub and spoke or daisy chain, the different ways we talk about meeting in a way that isn't meeting all at once. So passing things down the line or having us come together in groups of 2s and 3s to give us information or passing it along. That is, to decide that that isn't by definition a meeting is so antithetical to the spirit of Sunshine Law. No member of the community, no legislator for that matter, can possibly attend each of the steps along the way. So they're not attending the substance of the meeting. The second thing that is, let me just pair that by saying, while my friends in the First Amendment word community would, have me drawn and quartered for it, I think the appropriate amendment, the way to fix this bill, is to just exempt the General Assembly from open meetings law, as federal folks have done and as other states have done. It's extreme, but it would at least be a rule we would be following. When you effectively, we take the hit for a year and I don't know what would happen, but when you effectively limit it to the point that you're deciding that by definition, the thing that is a meeting is not a meeting, then just exempt yourselves, exempt ourselves. Our committee of reference meetings is thing number 2. I have only been here very briefly, but I am not aware of press or media knowing about those meetings around our party-based committee of reference meetings. I have a different view than my dear colleague who participated in legislation on this. I think those meetings should be allowed to be private. I think that the community would understand that parties, Republicans, Democrats, otherwise, should be allowed to have meetings that are not making the ultimate decision wherein you talk about if 6 of us want to run a bill on property tax, that we can have a meeting about who's the best person to run the bill on property tax. I think people will understand that that is not gross corruption to have that meeting in private. So I would want that to be protected. Finishing just to say, this was really heavy for me because the Judiciary Committee makes the rules, while every committee, of course, makes law. Your decisions impact whether people in Colorado get to keep custody of their children, get to stay in their homes, get to stay in this country, get to keep citizenship or be eligible for it, whether they can move about the world freely, whether they maintain their freedom at all. And it's just too heavy for the folks who, I'm speaking now as having been a member of that committee, for folks who are making those level of decisions to not follow our own rules. And unless we exempt ourselves, or at least make committee of reference meetings ones that can be held in executive session or otherwise, we're really doing a disservice to everyone else who's expected to follow the law.
Thank you. Members, any questions of Representative Epps? Christine.
Representative Epps, do you know, are you aware if the sponsors have considered your suggested amendments?
I have had occasion to speak with one sponsor. I would say yes, considered in terms of we talked about it. I don't have a sense that it was ever seriously considered. That was weirdly said. I know that they're aware of the suggestion. Let me clarify it this way, actually, Representative. I'm not sure if they received it as tongue-in-cheek or as serious. I don't like the rule. As a person who's filed a core request, I do not like the thought of my General Assembly saying, we are exempt. But I do prefer it to a messy set of rules that I can't expect to be followed and that I couldn't find out where the meetings were. So yes, that we mentioned it. I wouldn't say that I necessarily think that they took it as a serious suggestion.
We heard one of our members speak on the floor last year, where he mentioned not necessarily, and I might have gotten this wrong, so you can correct me. My recollection, which is not great, was he was not necessarily claiming exemption of the General Assembly in his floor speech, but he was more claiming the exemption of parties. So, for example, where then we could have those party caucuses you mentioned for committees to have those conversations of figuring out who should carry what's the issue, things like that. Was that something that you considered?
Thank you for the question, Representative. I don't have exactly the same recollection about what our colleagues said, but it's also a little messy because we've talked about so many iterations of it since. Are you asking about the party, if you were Dems, for example, 46, that meeting, or the committee of reference party meeting, the former? I am agnostic about whether or not that should be open or not. I think it is appropriate for people who work in the ways that we work to have opportunities for private fellowship where you do talk about some policy things, but you don't commit to decisions. For me, it is much more about, is the rule one we can follow? And a rule that includes that email as a meeting is not a rule we can follow. That doesn't make any sense. But when you sort of go, well, is text a meeting, is signal a meeting, then it just gets so messy that good faith actors, and I'm looking at good faith actors, by that I mean people who want to follow the rule, you can't be expected to care about this as much as I do. We can't all get right, we care about our different things. You also can't be expected to manage that level of minutia of a rule. So I would err on, I'm agnostic about whether or not that should be open, but I will acknowledge that that is a clear rule we could follow. We clearly could post, the meeting that I'm aware of, that I was aware of before I ran, was one set of meetings. I definitely didn't know when the House Judiciary met to talk about bills. I didn't know that. I couldn't find that online. So that's where the gap is for me between the large meeting and otherwise. And I just want to mention that this is a good, if you happen to be a Democrat, this is a good time to have that problem where your quorum is the quorum of the whole body, right? When Dems get together, you're not just a quorum of Dems, you're a quorum of the whole House. Knock on things that it stays that way or not. But I don't have a strong position about whether or not it should be. I care about whether or not the rule is one that we can follow and that the public can have a reasonable expectation of understanding it.
All right, members, other questions? All right, thank you. All right, last call. Anyone else in the room for 157? Mr. Mbala, last call. Okay, we'll close the witness phase on Senate Bill 157, and we will invite the sponsors back to the front. All right, to the amendment phase. Sponsors, do you have amendments for us to consider?
No, Mr. Chair, we do not have amendments.
Thank you. Committee amendments to 157. Seeing none, amendment phase is closed. Wrap up comments. Mr. Speaker Pro Tem.
Thank you, Mr. Chair. Thank you, committee, for some good questions and for this discussion. I want to just respond to a couple things that came up in the last witness panels because I think they paint a really interesting picture. First of all, When Representative Epps suggested to me that we just exempt the party caucus meetings, I did not take it as tongue in cheek. I knew she was serious because I know that what she has talked about throughout this process is, making sure that we have a clear law that we all know how to follow. I think that when we were developing this bill, this was something where we did discuss this idea, and I think we decided that we wanted to go with what the advocates of public transparency were arguing for in this case. It's a concession in a way that, and it's not really, when we talk about the party caucus of a committee of reference meeting to discuss a bill, it's never a concern about the press. It's kind of a concern about the lobby. It's, sometimes we may be discussing a bill where we believe that the interests of our constituents may not be the same as the interests of some, I won't name a lobby, but just, there's a number of well-funded groups down here that they have their own interests. A lot of the time it has to do with the bottom line profit. That is not the same as the interests of our constituents. And if we are inviting them into the meeting, that gives them a chance to put thousands and thousands of dollars into digital ads telling our constituents to call us so that we can vote no on such and such a thing. I think this is a real thing that a lot of us have seen over the last few years. And so when we conceded the point on these quorum meetings, it was because we recognized, most of the time, as Mr. Roberts said, we do believe that the press is going to be responsible. We've been posting our House Democratic Caucus meetings for nearly a year, and there have been a couple occasions where someone showed up and they found that the subject matter we were discussing was actually not all that interesting and wasn't going to make the front page of the paper. So I think that, we did grapple with this idea that Representative Epps suggested, and we decided that that wasn't the direction we wanted to go. We thought we could solve the problem a different way. I also want to talk about the example that Mr. Roberts brought up with Speaker Bledsoe, because I don't think this bill changes that. When we're talking about whether a series of one-on-one conversations constitute a quorum, the only thing that has to do with is whether minutes are kept and whether there is advance notice. That does not interfere with these meetings being open. Now, the definition of public business arguably could, but if you look at what's included in public business, it's quite broad. If there were a meeting in the Speaker's office, it was about a bill, a member of the press could walk right in. If there were a meeting in the Speaker's office or any other legislator's office about a bill draft that had not been introduced, or a budget request from some state department, or a legislative aid pay raise that was going to be before the executive committee of the Legislative Council, the press could walk right in. Our definitions of public business account for that. The only things where they could not walk right in were if it was a vague concept that had not been put on bill paper of something that is very far from being introduced into a committee, or one of these logistical or interpersonal questions. So I really think that the discussion, we could talk about the electronic communications piece. I agree that that's a little bit tricky here, but when we're talking about individual meetings, what I did not hear in response to Representative Amable's question was people saying, no legislator should not be having one-on-one conversations with each other. I did not hear the witnesses saying that. And so that really, I think that we're inviting you into this difficulty of how do you define these things? And what we believe that we've done with this bill is come up with a responsible clarification that says, if it's a bill draft, if it's a matter that's going to be before a committee, it's a public meeting. You may not have to post it 24 hours in advance if you're not going to have a contemporaneous quorum meeting, but the public is invited in just as they are under current law. And so we believe that what we have done with this section is provide this greater clarity. And if there's not actually an and, I'll just leave it right there.
Thank you, Madam Speaker.
Thank you, Mr. Chair, and thank you for the discussion. I appreciate the witnesses coming forward and sharing their perspectives. I too want to highlight a couple of things. Governance is hard. What has come before us in these discussions about open meetings law has been, I think, an earnest and honest one about how we can do this business and do it well by representing the diverse viewpoints of constituents and stakeholders and lobbyists and one another in those discussions. To think that exempting ourselves from everything in open meetings would, I firmly hold, would be absolutely against the will of our public of those that came forward with the Citizens Initiative in 1972 and said, we need to see transparency in government. And I hold to the absolute commitment that that needs to happen now, and it needs to happen with the clarifications we're putting forth in Senate Bill 157. I believe that one-on-one conversations are what make our engagement with one another and the production of policy effective. It's what we have been asked to do by our constituents. Listen to each other, move when we need to move to reach the right policy for this state. The idea that we are ensuring one-on-one conversations are still open to the public, that when we do meet in a contemporaneous quorum, that will be posted and minutes taken. We are trying to do our best to remain committed to those highest values and ideals of transparency and openness. I do believe that there is more work to do on Cora, and I am very open and have been talking with our stakeholders about the idea of records retention policies, of better defining work product. I think that is fair, and I think that is something we need to pursue. That does not fit within this bill, but I think that's right. I think posting that I am about to email the quorum of the House Chamber about the news of the day and new updates on procedures, having to post that and then make minutes of that are not what was intended when electronic communications was inserted into the open meetings law as it currently exists. So putting electronic written records under Cora is a better, more effective approach. Let's work on Cora if we need to do more there to make our written communications transparent. And finally, the idea of office hours, the idea that we're talking with one another. I certainly hope and believe that our members are engaging in stakeholding in very, very productive ways. I lift up the many members who are doing exactly that, whether it's office hours or having a meeting and inviting lobbyists, constituents to sit down and talk about amendments and bills. We need to keep doing that. I encourage that. That should happen. This is in no way trying to circumvent anything that try to circumvent open meetings law, try to circumvent the sunshine that should be shining on all of our work. It really is to provide better clarity and guidance for all of us. So thank you. I do hope that those individuals who would like to continue discussing Senate Bill 157 and how we can improve it are hearing me when I say my door is open, and I welcome further discussions. And today I look for your support of our effort. Thank you.
Okay, thank you, members. Are there any closing comments?
Thank you both for bringing this. Like I said in my questions, I do think that this is an improvement, specifically around when do we consider it public business is even before the act of introduction, and I think that's an important note. I personally, to the chagrin of some of the people, hate it when I'm like, I want to just put out my bill and just get feedback, and they're like, no, it's not ready, but whatever, that's the case. And so, what I want to say here is, I think because of what's happened, we have seen a decline in our ability to work with each other, but we've also, I believe, that we've also seen a decline in being able to work bipartisanly. The reason I say that is because earlier this session, I requested an opportunity to speak with my colleagues on the other side of the aisle, to go to their caucus meeting, to have a conversation about a bill that I was bringing. Because I wanted to have that conversation, to hear and air out any concerns, and I was denied the opportunity to go speak because they did not want to post publicly that I was coming to speak with them. It concerns me that the idea of transparency makes people unwilling to speak to each other, unwilling to engage with the other side of the aisle if any sort of public notice has to be made. I find that also disingenuous when we are talking about upholding transparency. I know that this is not easy. This is not going to be an easy vote for anyone. I don't believe it's easy for me, but I don't know that it'll be easy for everybody here. Because I think some people will construe a yes vote for this as against transparency. some people will construe a no vote as being the wielder of protection of transparency, and I don't believe either is true. And so I don't know where that was going, but I just want to say that I thank you both so much for bringing this. I understand the concerns that we heard. I do wonder also maybe if there is opportunity for discussion, because I've always been a proponent of exempting parties from open meetings law. And whether that's in this bill or in a future bill, I do want to have that conversation openly and transparently, and I'll be a yes vote. So thank you.
Thank you. Members of the closing comments, Rebel Modeler.
Thank you, Mr. Chair, and thank you, bill sponsors. And I get that this is a hard issue, but for me also an easy vote. And we need some clarity around what we're meant to be doing here. And we have been thwarted in getting our work done because we don't have that transparency. And to your point, no one was able to say to me, well, we just don't want you talking to your colleagues. And we absolutely need that transparency. So that clarification so that we know we can, in fact, talk to our colleagues, because otherwise we can't do a good job for the people of Colorado. So I think you've struck the right balance, and I appreciate the effort, and I understand if people think we are trying to exempt ourselves from the rules, but it really doesn't feel that way to me. It feels like people are saying we would like to support you in getting this important work done.
Members of the closing comments. Sponsors, thanks for bringing this to this committee. I think I'll just note two things. The statute that we're working in is a bit of a mess. I've read it over and over and over again, and I find parts of it, particularly to the question, how does the statute intersect with CORA, to be not only incoherent now, but probably incoherent as of the time that some provisions were amended in decades ago. So I think clarity is needed. I think more importantly, we have seen today and in the press, there's been a bit of a members of this place and a press dichotomy, but I think something is left out of that. It was alluded to here, but I want to make it more explicit, and that is frankly our own constituents. In this chamber, we all are here to try to do right by 85 or 90,000 souls, or a greater number for our Senate colleagues. Those folks may belong to an association or a union or some other group that comes here once a session or even has a lobbyist. They may find their interests represented, at least indirectly. They may like votes we take or not, but for the most part, each of us is all 85,000 people have down here. I have even used the phrase, although I don't like it. We are the lobbyists for our constituents. 1 to 85,000, that's a pretty daunting ratio. Obviously, there's a First Amendment right to petition your government. From that right flows the right to hire somebody to do it for you. Anybody who wants can hire a lobbyist. Some individuals have a lobbyist, and obviously some large organizations do. There's not inherently anything wrong with that, but I think when we consider who the 6 million people in this state are, how they think, their needs, their preferences, I would posit that the good folks that we engage with behind the glass, and I don't mean anybody in particular here, are maybe not quite a fair sample, statistically speaking, of the 6 million folks, which brings it back to us. Mr. Speaker Pro Tem, I have had similar thoughts in terms of how you framed it. I believe that this place is about change and progress, and that it's hard sometimes, and you don't take on change and progress, whatever that means to any of us, in taxes or social policy or criminal justice or whatever, without sometimes some friction and even some opposition that to the end is never neutralized by amendment or discussion, but it really kind of just comes down to, at the end of the day, who has more votes net of the choices that the voters have made in the last election cycle or two. So for the sake of change and progress and our constituents being empowered here against sometimes very formidable forces in opposition, it does matter that we can talk amongst ourselves as far as advancing the values and goals that we were sent here and took an oath on the Constitution to do, without, frankly, more of a disparity than already exists. We are talking about a legal framework that covers public officials. There are folks not under this framework. Fortunately for them, I suppose, members of the professional lobby corps are not. that works a disparity, and a massively troubling one in my estimation. We have seen that arise in the last year. It is new in my 8 years of experience here. So, among other things, and moving back to the issue of needed clarity, I see this today as trying to rectify that a little bit and put a constitutional branch of government elected through small d democratic processes to come here and in the best way that we all can carry the voices and desires of our respective constituents into this place for a few years at a time, to actually do that in a way that is meaningful, that is what representative government is about, without being broken. So that might be pretty big, but it is the framework through which I've been viewing a lot of these discussions in the past year. For that reason, I'll be supportive. All right, members, the motion is to the committee of the whole. Madam Vice Chair.
I thank you. I move Senate Bill 157 to the Committee of the Whole, the favorable recommendation.
The motion is by Madam Vice Chair. The second is by Representative Garcia. Mr. Poe, please call the roll on 157.
Representative Zamabale,
Yes.
Armagost,
No.
Evans,
No.
Garcia,
Yes.
Herod,
Yes.
Lynch,
No for today.
Mabry,
Yes.
Snyder,
Yes.
Woodrow.
Yes.
Bacon,
Yes.
Mr. Chair.
Yes. Vote is 8-3. Congratulations, sponsors.
Thank you.
Thank you.
All right, members, we have 3 bills to go. I'm gonna, again, take just a 5-minute recess so that the room can reset, so that folks who have been here for the last bill can leave if they wish. I know that we have other witnesses who probably want to come in here for the next bill. We will get going again at 20 minutes after 5 to commence with House Bill 1289. Until then, judiciary is in recess.
Hey. How's it going? Good. How are you? Living a dream?